Thank you for joining us once again on TVC News this hour. We begin with the ongoing strike by the non-academic staff universities, which commenced last week. The federal government has released funds for payment of withheld salaries of the non-academic staff union of federal universities. In a statement by the Office of the Accountant General of the Federation, the federal government has also released funds for the payment of benefits to retirees under the Nigerian Union of Pensioners Contributory Pension Scheme sector. The statement mentioned that payment to the non-academic staff of federal universities had commenced, and many have confirmed receipt. This development comes following the commencement of a nationwide strike by NASU and the Senior Staff Association of Nigerian Universities last Sunday. And talking politics ahead of the November 16 governorship election in Ondo State, members of the Ebira community in the state have expressed their support for the governor, Lucky Aiyedatiwa. Governor Usman Ododo of Kogi State led the Ebira community in Ondo State to drum support for the governor, Aiyedatiwa. Mr. Ododo said the entire Ebira community across Ondo State have resolved to support and vote for the All Progressives Congress in the coming election. In his response, the governor expressed gratitude for the community's support and praised President Bola Tinubu's commitment to Ondo State's economic development.
He's an easygoing somebody, very calm, very matured. You see him, you see unity. You see him, you see understanding. You see him, you see maturity. You see him, you see leadership. You see him, you see development. By the special grace of God Almighty, my brother, Dr. Lucky Aiyedatiwa, will continue the good work he has started already.
What he has done today has added great strength to our position in the Northern Senatorial District, more particularly in our work, by mobilizing his people to vote for our party, APC. This endorsement, no doubt, will add more to the votes we are going to get here in our local government.
And away from politics, the Abuja Municipal Area Council says it will begin the conduct of a general assessment and valuation of all properties to enable the council update its records and have accurate data for an effective tenement rate administration. Senior reporter Habida Lawal reports.
Tenement rate collection is a statutory responsibility of the local government as enshrined in Section 7 and the 4th Schedule 1J of 1999 Nigerian Constitution as amended. In view of this, the Area Council has appealed to residents of Abuja living within AMAC that its tenancy assessment will involve certified surveyors carrying out physical checks for the purposes of enumeration, automation, and data capturing for assessment and valuation.
The danger in you not allowing the professionals to come into your compound or your estate or wherever to assess what you have, you bear the brunt. Like I earlier said, the bylaw stated it very clear that in you not allowing the assessment to take place, you have committed an offense.
The exercise is going to take much of your time. If not, the anchor has said it, maybe 5 minutes, if at all it's up to 5 minutes. And we are still soliciting for cooperation. We know in the past, people are reluctant to allow professionals have access to their properties. We are soliciting for your cooperation. Give us that maximum cooperation so that your properties will be properly captured.
Please, if anyone asks you to take him or her into your apartment, please refuse. Our field officers are trained to take their data externally without going into the property.
The combined effect of the legal and judicial framework for collection of tenancy rate in the FCT is that area councils have powers to legislate on, assess, demand and collect tenement rate in the FCT. Habida Lawal, TVC News, Abuja.
And away from that, the Attorney General of the Federation, Lateef Fagbemi, has asked the police to transfer the case file of protesters arraigned on the 1st of November at the Federal High Court in Abuja before Justice Obiora Egwuatu, who were alleged to be minors. The AGF in a press statement says there are some issues his office will need to look into to make an informed decision. Celestina Area reports.
On 1st November 2024, the Nigerian police arraigned 119 protesters before the Federal High Court in Abuja. Out of the 119, 76 were believed to be minors, while 43 were above 18 years. They were arrested on 3rd August in various parts of the country: Abuja, Kano, Kaduna, Zaria, Katsina, Gombe, and Jos. They were arraigned before Justice Obiora Egwuatu on a 10-count charge of terrorism, attempts to overthrow the government, and mutiny over their participation in the nationwide protest which took place on 1st to 10th August 2024. They looked pale, starved, and exhausted. 4 out of the alleged minors slumped in court when docked to take their plea. These startled Justice Egwuatu and forced him to rise abruptly. Lawyers for the defendants scrambled to obtain snacks for the suspects to boost their energy levels.
12, 13, 14 years old.
Shortly after, the court reconvened. Justice Egwuatu struck out the names of the 4 defendants who slumped due to ill health, after which the remaining defendants pleaded not guilty to the charges when it was read to them. They were subsequently granted bail in the sum of 10 million naira each, with 2 sureties in like sum. The judge held that one of the sureties must be a level 15 civil servant and the other a parent of the suspect. The sureties must make available to the court a means of identification with a verified address, letter of last promotion, and letter of appointment. The defendants were remanded at the Postal Center, Kuje, pending the perfection of their bail conditions.
We will strive and do our best to perfect these conditions. But if we cannot meet those conditions, we will come back to the courts and seek for a variation.
Counsel for the prosecution disagrees with counsel to the defendants that they are minors.
These boys that we brought to the court today, all of them are adults. Most of them are married men. None of them is a minor. Some of them are university graduates. The small kids you are seeing here, they came with some of their parents to come and greet their loved ones.
The Attorney General of the Federation, Lateef Fagbemi, has asked that the case file be sent to his office. The AGF in a press statement says that there are some issues his office will need to look into regarding the matter to enable him make an informed decision. He says the case was adjourned to January 2025 and it is not within his powers to vary the order of court, remanding the defendant in detention center and the adjournment. However, he has instructed the Director of Public Prosecution of the Federation to immediately begin the process for consideration of the court to bring the adjournment to an earlier date. Section 174, subsection 2B and C of the Constitution empowers the Attorney General to take over and continue any such criminal proceedings that may have been instituted by any other authority or person, and C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by him or any other authority or persons. But there are some controversies across various jurisdictions on the contextual definition of a juvenile or a child. The Child Rights Act 2003 defines a child as a person under the age of 18 years. However, Section 2 of the Children and Young Persons Act states that a child means a person under the age of 14 years. Article 1 of the Convention on the Rights of Children defines the holder of rights under the Third Convention as every human being below the age of 18 years. The 2 major sources of criminal law in Nigeria are the Criminal Code, which applies to the southern states, and the Penal Code, which applies in the northern states. Both laws make provision for juvenile as follows. Section 30 of the Criminal Code provides that a person under the ages of 7 is not criminally responsible for his act or omission unless it is proved that at the time of doing the act or making the omission, he had the capacity to know that they ought not to do the act or make the omission. Also, Section 50 of the Penal Code provides that no act is an offense which is done by a child under 7 years of age or by a child above 7 years of age, but under 12 years of age who has not attained sufficient maturity of understanding to judge the nature and consequence of such act. What these two sections imply is that in Nigeria, a child of 7 years and above can be prosecuted, but this must be done in a juvenile court. From the provisions of the Child Rights Act, juvenile cases are handled in family courts. Such courts are usually at the high court level and magistrate level, and the magistrate and judge could be assisted by assessors. The assessors at the magistrate level must be officers above the rank of senior development officers, whereas at the high court level, they must be above the rank of the chief social welfare officers. The officials handling juvenile cases must have the capability to do so, for such cases involve children. Officers like the judge, magistrates, and officers of the specialized police unit, supervisors, and child development officers. These basic rules governing juvenile trials must be adhered. Child trials cannot be held in public. Certain words are not permissible for use in courtroom, such as sex, imprisonment, sentence, conviction, and only the court can give authority before the child's identity can be made public. For now, it is unclear if the court will consider the Child Rights Act while determining this case, or it will focus on the Penal Code. Celestina Ira, TVC News.